FYI with BBL.
In 2019, Botswana put pressure on the government to address corruption in land boards. Heeding to the call of the people, the Ministry of Lands and Water Affairs began investigations into the corruption. It was discovered that many employees of the Mogoditshane Sub-Land Board were beneficiaries of a scheme which had been put in place by the Gweneng Land Board to address land shortages. Under this arrangement, fields were acquired from owners in exchange for residential or business plots. A number of land board employees who knew which fields would be acquired allegedly purchased them for themselves, then immediately surrendered them to the land board for compensation. It was alleged that Mokgosi was one of those employees. He was charged and his hearing was scheduled for April 2021. The day before the date of the hearing, he filed a letter seeking a postponement because his representative would not be available. The meeting was postponed to 17 May and he filed a sick note. In September, Mokgosi could not attend the hearing as he had to attend a funeral. Finally, he was informed in November that the hearing was postponed to December. At the hearing in December, he tendered another sick note. Ironically, while Mokgosi is the one who produced the sick note, it was the chairperson who grew sick and tired. He was of the view that the sick note should have been tendered earlier and that Mokgosi was given adequate opportunity to defend himself. For this reason, the hearing continued in Mokhosi's absence and he was informed at the end of January of the employer's decision to dismiss him from employment. He believed it was unfair and approached the High Court. He succeeded in his claim that he had not been heard and the employer appealed the decision. So, was Mokhosi's right to be heard violated? Well, there is a fundamental principle known as natural justice which requires that every party against whom an allegation is made be given an opportunity to defend him or herself. The court's view was that the submission of sick notes the day of the hearing or the day before raised doubts about their authenticity and reasonableness. In addition, the court found that Mokhosi's conduct demonstrated an unwillingness to participate in the hearings. It concluded that the chairperson was correct in ordering that the hearing proceed in Mokhosi's absence.
What are the lessons from this case? You cannot avoid a disciplinary hearing forever. If your employer accuses you of acting unlawfully or breaching the employer's code of conduct, it is in your best interest to attend that disciplinary hearing and defend yourself. Who knows, you might just win. Your right to be heard is not absolute. If you make it impossible for you to be given a hearing, you lose your entitlement to one. See you next week.